welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we take you through the latest legal developments across the nation. Let's take a look at the headlines. Supreme Court introduces standard operating procedures for summoning government officials. PIL in Supreme Court challenges the new law for appointments of Chief Election Commissioner and Election Commissioners. Kerala High Court dismisses apportioned plea for 12-year-old in alleged incest case. Orissa High Court calls for Counter Affidavit in 2008 VHP leader murder case. Now the headlines in detail. In a landmark decision today, the Supreme Court has declared that arbitrary court orders summoning government officials in judicial proceedings contradict the constitutional framework. The bench, led by the Chief Justice of India D.Y. Chandrachud, and also including Justice J.B. Pardiwala and Justice Manoj Mishra, not only upheld that personal appearance of public servants be exceptional, but also introduced standardized operating procedures to govern such summoning practices. The SOP, as outlined by the top court, underlines the imperative for courts to refrain from arbitrarily issuing summoning orders for government officials. The CJI emphasized that officials should not be summoned merely due to differences in their views compared to the courts. The Apex Court also highlighted the importance of maintaining a respectful environment, stating that making remarks or observations to humiliate officials during court proceedings is unacceptable. In a specific case, the Supreme Court set aside orders of the Allahabad High Court, which took two secretaries of the Uttar Pradesh Finance Department into custody for alleged non-compliance of directions pertaining to facilities of retired judges. A public interest litigation has been filed in the Supreme Court, challenging the gazette issued by the Centre on December 28th of the preceding year, pertaining to the appointment of Chief Election Commissioner and other election commissioners. The PIL urges the top court to set aside the gazette while proposing the inclusion of the Chief Justice of India in the selection committee. The petition is filed by Advocate Gopal Singh, who contends that a neutral and independent selection committee be established for the crucial appointments. Originally, the bill titled Chief Election Commissioner and Other Election Commissioners, Appointment, Conditions of Service and Term of Office Bill of 2023 was introduced in the Rajya Sabha on August 10, 2023 by the Law Minister Arjun Ram Meghwal, and it received the assent of the President on December 28, 2023. It is pertinent to note that the bill gained momentum following the Apex Court's verdict passed on March 2, 2023 that emphasized the need for a law governing the appointments of the Election Commission of India and suggested interim appointments based on the decision of a committee comprising the Prime Minister, the Chief Justice of India and the Leader of Opposition in the Lok Sabha. However, the existing committee comprises of the Prime Minister, the Leader of the Opposition in Lok Sabha, and a Union Cabinet Minister nominated by the Prime Minister. At the heart of the matter is the question whether the Parliament holds the authority to nullify or amend a judgment previously delivered by the Apex Court, especially when the judgment originated from a constitution bench. In a recent decision, the Kerala High Court has denied permission for the medical termination of a 12-year-old girl's pregnancy, which is alleged to have been a result of an incestuous relationship with her younger brother. The court's ruling is based upon the advanced stage of the pregnancy, reaching 34 weeks with the full development of the fetus. The medical board initially recommended the termination of pregnancy, considering the young age of the girl and the associated psychological trauma. However, upon further deliberation, the board altered its stance, asserting that the minor should go on to give birth to the child and was fit for the same. The plea was filed before the High Court by the girl's parents, seeking approval for the abortion and citing potential physical as well as psychological repercussions for their daughter. The parents informed the court that they were unaware of the pregnancy until it progressed significantly. The matter was placed before Justice Devan Ramachandran, who directed that the minor be put under the care and custody of her parents, with stringent measures in place to ensure that her brother remains isolated and away from her. The court, though dismissed the plea for abortion, it has mandated continuous medical support for the petitioners. Post-delivery, they are also eligible to seek the assistance under the Juvenile Justice, Care and Protection of Children Act of 2015. In a significant development, the High Court of Orissa has instructed the state government to file a counter affidavit by March 5, 2024, in response to a petition seeking a probe by the Central Bureau of Investigation into the killing of Swami Lakshmanan Saraswati, a prominent leader of the Vishwa Hindu Parishad, along with his 4 disciples. Swami Lakshmanan and his followers fell victim to an attack by at least 15 masked assailants at the Jalaspera ashram situated in the Kandhamal district. Advocate Devashish Hota, the petitioner in the case, argues that the initial investigation that was conducted by the crime branch of the Odisha police failed to establish the precise motive behind the heinous offence. Following preliminary arguments, Justice Chitranjan Das, the presiding judge bench, issued a notice to the state government, urging them to file a counter affidavit. The matter is now scheduled for March 5th for further hearing. That was all on today's legal news. Thank you and keep watching Verdictum, and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.